All right, we'll get started. So as I already said, my name's Angela. I'm the Education Coordinator with Taranaki Community Law. The Incorporated Societies Act is a really big deal, and I have been running workshops around the Incorporated Societies Act changes for the past couple of years here in Taranaki. So the purpose of the workshop today is to hopefully make you feel a little bit more empowered to be able to go forward and actually make the changes that you need to make for your organisations. It is important to note that you do have to make changes. This is not an optional thing, but hopefully relatively painless. I'm going to be asking you to do some things as part of this online presentation. So if you've got a pen and paper or a Word document or something like that, that would help you. And there are some polls which I will be putting up at the end. So if you've got an opportunity to do those before you leave, that would be really helpful for me. Okay, so can everybody see my screen first of all? Yes, excellent, fantastic. So what we are going to take a look at is looking at changes that need to happen to your constitution. And just a heads up, you will have to make changes to your constitution. It's part of the new requirements. Then we're going to take a little bit of a look at some of the changes that have occurred with membership. Some of the requirements around your committees, that's your governing kind of entity. And then finally, a bit of a brief look about your finances. Don't stress too much about your finances. Chances are good you are already at least meeting the requirements and possibly even exceeding them. All right, and this is the re-registration process, right? So October 2023 was when you could start re-registering, and you've got until the 5th of April 2026. That might still seem like a bit of time, but I'm afraid I have to tell you it's probably not. One of the changes that you have to make is changes to your constitution, and that will take a little while to organise. So we are starting to hit the real pointy end of the re-registration period when it comes to making these changes that you need to make for your societies. So let's start by taking a bit of a look at your constitution. Now, there are some new requirements in the Act, and these new requirements need to be reflected in your constitution. So your current constitutions, which are under the old Act, will no longer be sufficient for these new requirements. So you will need to change your constitution. But the good news is that this is also a really good opportunity to have a look at your current constitution and make other changes as necessary anyway, because you're going to do it, you might as well look at all of those kinds of things. So we've had a question by wait, let me pull up the chat. By registration, do you mean registration in the NZBN website? I mean registration with the Incorporated Societies Register. So the Incorporated Societies Register can be accessed through the same portal as companies, but it is actually its own kind of specific thing. So when you go through this re-registration process on a practical level, you're going to redo your constitution, and we'll look at those requirements in a sec. You're also going to pass a resolution that you want to re-register under the new Act, and then you're going to provide those two things to the Incorporated Societies Register. And if you're currently using that website, like in that way, then that's totally fine. That's the way you would do it. So however you normally put in your annual returns is the same way that you will put in your constitutional change and your resolution to re-register under the new Act. Okay, and then they'll accept or deny that constitution. It's very unlikely they would deny it. And then you will be registered under the 2022 Act. So you can, in fact, if you search the Incorporated Societies Register now, you can see which societies are under the old one and which are under the new one. All right, so constitutional changes. You should see on your screen a whole bunch of words. What I would like you to do is there's some words down here at the bottom. All I'd like you to do is figure out which ones fit into which of the parts. So these are the changes that need to happen, or these are the things that need to be in your constitution. So I'll give you a couple of minutes, see if you can figure out which words go into which of the spaces. I'm not in the habit of tricking people, so if one of them's got 3 words, that's probably where it goes. So there are some things that your constitution requires. Some of these are what they already require. The first is, of course, the name of your society. Now, under the new Act, you can choose to have the word Inc. or the word incorporated or the word mana tōpū at the end of your name. So you've got more options for the end of your name than you did previously. Your constitution's also got to contain the purposes of your society. So this is a really good opportunity to take a look at what your current constitution says and see if those purposes are what you are actually doing. And if they're not, maybe you could make some changes to those purposes at the same time. It's got to contain information about how a person becomes a member, including a requirement that they must consent. And we'll look at membership and consent in just a second. You also need to contain information about how someone ceases to be a member of a society. You need to have information about the society's register of members, and this is a new requirement under the Act that you must keep a register of members. And again, we'll look at that in just a second. And you've got to have information in your constitution about the composition, roles, functions, powers, and procedures of the committee, including the number of people that should be on it, any quorums that you think you need to have, functions and powers, grounds for removal from office. You also need to have information about the contact person. So again, this is another new requirement. Contact person or persons is someone that the registrar of the incorporated societies can get hold of if they need to contact you. So one of the things that became clear when they were reviewing the old Act was that it can sometimes be really hard to get hold of incorporated societies because they haven't updated their details, they've got old email addresses floating around, and it's hard to get information to and from them. So the contact person is a new requirement. This is something that you must have. It would be good practice for your contact person to be someone different than the person who puts in your annual returns. Because if the person who puts in your annual returns doesn't do it, there's not much point having them as the contact person because then nobody else would know. You don't have to specify who the contact person is in your constitution. You can just say something like, the contact person will be elected or appointed by the committee. That's totally fine if that's how you want to do it. You can say something like, the contact person will be the same as the secretary. Okay, or you can say that the contact person will be elected at the AGM. Whatever you want to do. It doesn't make any difference as long as there's some information in there about how that will happen. How you will control and manage your finances. Procedures for resolving disputes. Again, this is a new requirement. There are some mandatory clauses in the Incorporated Societies Act, so these are the defaults. If you don't have a specific dispute resolution process that you want to follow, you can just use those default provisions that are in the Incorporated Societies Act. And then arrangements and requirements for general meetings. Now, if you've got a quorum for your AGMs or your SGMs now, and you're struggling to meet that quorum, then this is a really good opportunity to think about whether or not you want to change up that number because you're going to have to make changes to the Constitution anyway. So it's a really good opportunity to look at things like quorum and see whether or not that is actually meeting what you're actually doing. A couple of other things to note. There is no longer a requirement for you to have a common seal. So if you don't know where your common seal is, you can take that part out of your constitution. If you've got a common seal and you want to keep using it, that's totally fine. You can keep that in the Constitution if you want. It's just no longer required. As well as that, this is a good opportunity to look at whether or not to contain information about auditing or reviewing your finances. So many constitutions will say that you need to have your finances audited. Auditors are really hard to come by, so you might want to make changes around that. It's up to you. Some incorporated societies feel quite strongly that they should continue to have their accounts reviewed or audited, that's completely fine, but it is not a legal requirement to have that in your constitution. In terms of actually doing this work, the Incorporated Society's website has a really good constitution builder. So you can go there, put in all the details, and it'll provide you with a draft. And then you take that draft to your committee meetings and make whatever changes you think you need to make, and then submit it to the Register of Incorporated Societies. So you can be pretty satisfied that if you're following that draft constitution builder that's available, you are likely to be hitting all of the right pieces of information. As well as that, I forgot what I was going to say. Something about, I'm sure it will come back to me. So, that's what it was. I knew it would. One of the things that you should be aware, so that you don't freak out, is that it's likely that your constitution under the new Act will be significantly larger than your previous constitution. So most constitutions probably 5 to 10 pages. Currently, under the new Act, you're looking at more like 27 up for the size of your constitution, just because there's a bunch more information that needs to go into your constitution now that didn't under the previous Act, especially if you're using that draft builder. You don't need a lawyer, so you can do it without legal advice. But if you thought you maybe would like some legal advice, now is a really good time to hit up any of your members, it might be lawyers, and ask them to provide some of that for you. All right. Any questions about constitutions before we move on? Does community law provide free legal advice? Yes, we do. So we can take a look at your constitution. We can't, if you're a big society with lots of money, we would expect you to go and seek your own legal advice. But if you were a smaller society and you just needed someone to kind of have a look over it, then that is something that our lawyers can do. And there is no cost for that. And at the very end of my presentation, I'll put up the details for our service here in Taranaki. Yep, so you guys are New Plymouth Rodders, I think you're on mute.
Yep. Yep. Yeah. Hi, Angela. Look, currently to make amendments to the Constitution, we do it by remits, normally at an AGM.
Yep.
Do we have to take remits to the members for any changes that we're going to make to the Constitution, or do we just draw up the draft and present that to them and say, hey, this is the new Constitution with all the rules we want in it now?
Yeah, that's a really good point. However you currently do it to make changes to your Constitution is the way you will have to do it to make these changes. So if currently you need to provide them with the remits first, then that's what you would need to do. Okay. So whatever your current, like whatever the process is to make constitutional changes currently, is the process you'll have to follow. And that's one of the reasons we're actually at quite a pointy end of this process, because this will take some time.
Yes, yes.
Right? Like you're going to have to do the work, take it to the committee, then put it out to your membership at large, then have some kind of general meeting in order to agree to it.
Great, thank you.
No worries. All right, we had another question. Are any committee or members personally legally responsible for the actions, etc., etc.? Yes, and we will cover that when we talk about the responsibilities of committee members. Define a smaller society. Look, our purpose at Taranaki Community Law is to provide legal advice to people who can't otherwise afford a lawyer. So if you were a society that could not afford to engage a lawyer and you needed legal advice about your constitution, then we could potentially provide that advice. If you had really high membership fees or members were willing to pay a little bit extra to get that legal advice, then we would expect you to seek that yourself. But to be clear, you don't have to get a lawyer in order to re-register. As long as you are meeting the requirements, it is okay just to go through that re-registration process by yourself. Okay, all right. Let's move on and take a little bit of a look at membership. So this is another area where there have been some changes. So one of the changes that needs to be in your constitution is what's called a register of members. This is a new requirement under the Act. So what we've got here that you should be able to see is we've got a little table and then we've got some blank boxes. All I want you to do is work out which of these 4 things down the bottom fits into which of these labels. And again, we'll have a bit of a discussion once you've done that. So these are the things that need to be in your register of members. So the first thing, obviously, the members' names. That's pretty straightforward. Shouldn't be any difficulty there. You need to have their last known contact details. Now, what contact details you gather is kind of up to you. You might need to know postal address, email addresses, cell phone numbers, whatever, but it just needs to be some kind of contact details from the member. So however you are currently getting contact details, whatever those are, is likely to be sufficient. Your register of members also needs to contain the date that they became a member. Now, this only applies from once you have re-registered. So for your current members, you don't need to worry. Okay, so you don't need to know when they started being members of your incorporated society. But once you have re-registered, because there is now a requirement that members consent, you should be able to identify when a new person becomes a member of your society. And that information needs to be on your register of members. If they're a current member, you can put something like unknown. If you knew the year but not the exact date, you could just put the year, for example. And then this last one is the date on which they cease to be a member. Now, for many incorporated societies, this will be very straightforward. People will cease to be a member when they tell you that they no longer want to be a member, when they've been removed, or when they have died. But for sporting organisations, this one's a little bit trickier. So you've got to keep this information about when people ceased to be a member. So you've got to have the date on which they ceased to be a member. You've got to keep that information for 7 years. Okay, so again, for most incorporated societies, that's fine. But if you've got a really high turnover of members like sporting groups do, this is actually a pretty significant administrative burden that you'll have to put down the date on which they ceased to be a member, and you'll have to keep that information for 7 years. Now, if you are currently using a registration engine, for example, Sporty or Comet or PlayHQ, that may not have all of the information that you need to be a register of members. So currently, for example, so I'm also the junior coordinator for my football club, so I know this from both sides. Currently, for example, Comet cancels everybody's registrations on the 31st of December, but you don't necessarily want your people to stop, everyone to stop being a member at that point, because then that would leave you, again for football, that would leave you without members until like March or April. And so you're going to need to think about how you manage where you've got high turnover of members. So we had a question. Our swimming club falls under Swimming New Zealand. Do we need to create our own personal register of members? Yes. So you are yourself an incorporated society. yeah, Poop is right. You are an incorporated society, so you have an obligation to have a register of members for your swimming club, which is separate from Swimming New Zealand's obligations to have a register of members of all of their members. Okay, now it might be that whatever database Swimming New Zealand is using can also be used as your register of members. That's totally fine, provided you can get out the information that you need. Name, contact details, when they started being a member of your club and when they ceased to be a member of your club. So if you can get that information out of Swimming New Zealand or a national body's database, that's totally fine. You can use that as your register of members. But if you can't, then you will need to have a separate register of members specifically for your incorporated society. Questions around consent. Okay, we'll talk about that right now. The question is around consent. Can I put a short disclaimer that upon payment of an invoice, they consent to join our society as a member? The important thing here for the purposes of membership under the new Act is that people have to consent. Consent is a positive step. So they have to do something. So saying that, so if you put it on the invoice before they pay, then that may be consent, right? Because then they understand that the payment of the invoice is them consenting to be a member. Historically, incorporated societies have tied membership to the payment of subs. That's because previously there weren't any rules around member consent, and it became a little bit unclear about when people were members and when they weren't. That's no longer the case. It's going to be very clear when someone's a member. You don't have to tie membership to the payment of subs. And you can run into some problems around this. For example, you put that on the invoice, but then they don't pay. That means that they're not a member of your society, which means that the Constitution is not binding on them. So if you have a dispute with them, you can't use your Constitution in order, to resolve that dispute because they're not a member, because they haven't paid. So you can do it that way, but you don't have to. When it comes to consent, you just want some kind of positive step that they are taking. If we have free membership, does everything said apply? Yeah, it does. Okay, so there's no legal requirement that members have to pay. You can have members without any payment. That's no problem at all. But all of these rules still apply because you are still an incorporated society. All right, so we've got an example about consent. Go through this example and then talk a little bit more about what consent might look like, and hopefully that will also answer those consent questions. So Arlo registers to play football with his local club. At the bottom of the form is a box saying that by registering, he consents to be a member. Has he consented? Hands up if you think, yep, he's consented. You can do it in person or you can use the chat function. Hands down if you think no. So hands up if you think, yes, he's consented. Yep, we got some hands up. Cool. Yes. Yes, this would be enough, right? So there's a tick box. There's a box saying that by registering, he consents to be a member. So therefore, him completing the registration is membership consent. Again, he's taken some kind of positive step. So that registration can be considered consent to be a member of the incorporated society. As well as that, you've got a clear kind of date on which that happened, so it's obvious when that happens. If you have a form that someone could fill in on the internet, join our society section, little form to fill in and, submit, that would also be enough to be consent because it's clear that by filling in the form and clicking submit, they are consenting to be a member. You can do it as a written thing. Technically, it doesn't have to be in writing, but I would strongly suggest that you get any kind of membership consent in writing. What if Arlo here, though, is 4? Does this make any difference? So the Act is a little bit silent about how membership is supposed to work for children. So most of the time for incorporated societies, where you've got children or young people, you want them to be your members, but they can't legally consent. So then a parent or guardian is likely to have to consent on their behalf. And this could potentially cause problems. Now, in practical terms, for the vast majority of the time, you won't have any difficulty, but I just want to highlight that this could be a little bit problematic. So some of the things you need to consider as parent representatives on your committee, because if the child is the member, the parent is not. And so then you might need to get that parent to consent to be a member separately of the child so that they can then be part of your committee. It also raises some problems if it's, 14, 15, they're playing in a senior competition, for example, for sports, and you might want them to be personally responsible, or they might have signed up without actually having a parent or guardian consent on their behalf. So this has been raised with the government as a bit of an issue, but we haven't had any resolution. As I said, for the vast majority of the time, you won't have any difficulties in terms of the practical running of your clubs, but you should just be aware in the back of your mind that it's a little bit unclear about how this is supposed to work when you have children as your members. All right, any other questions about membership? As an expectation on how frequently lists should be updated. This is actually a really good question. So you've got to keep a register of members. Whether or not that means, so it should be up to date pretty much all the time, right? Because when someone becomes a member, you should be adding them to that register of members. And when someone ceases to be a member, you should be removing them or adding that ceases date on there. So as those things happen, you should be updating it. It is a requirement of the Act, but you don't necessarily have to show anybody. The only thing that might happen is that a member might ask to see it, or if your membership drops below 10, which is the minimum number that you have now, then, and you would know that because your register of members would show that there were less than 10 members, then you must tell the Registrar of Incorporated Societies, and you've got 6 months to bring your membership back up over 10. If you can't do that, then you will cease to be an incorporated society. So one of the purposes for this register of members is to ensure that you have at least 10 members at all times. So the expectation is that you're updating it in real time as things are happening, because that's that requirement. So you've got to have at least 10. And if you don't have 10 members, you've got 6 months in which to bring your membership back up to over 10. If you can't do it in that 6 months, then you will be removed from the Register of Incorporated Societies. You'll no longer be an incorporated society at that point. If you're currently sitting around that 10 member mark, now's a really good time to kind of think about what your best option is going forward. Is it to re-register? Is it to change the way you do membership to try and gather more members? Are there some other options that you've got, for example, amalgamating with other clubs or other incorporated societies that have a similar purpose to yourself? If our community is not sport but culturally based, do we need consent from every family member? Or can one person sign on behalf of the family? Okay. So on the Incorporated Society's website, they do have an example of family membership. My personal opinion is that this is a terrible idea. The real challenge with family membership is, what does that actually mean? Part of the purposes of having members needing to consent is because previously we didn't have that and people were being joined to societies without knowing. And so family membership where you can sign on behalf of another adult is probably not meeting the purposes of the Act. It's a little bit less clear if you're signing up on behalf of your children. As well as that, if you did want to go down the road of family membership, and, like legally you may be able to, I can't say for certain one way or the other, you need to think very carefully about how many members that is. Right? Because one of the things that members get when they become a member is the right to vote, right? The right to make decisions about your society. So if every member of that family has the right to vote, including the baby, for example, then this might lead to some consequences for your organisation. So again, my personal opinion, not the opinion of community law or anything like that, is that this is not a great option just because of those issues around consent. In terms of getting consent of the whole family, like if they're going to all be members, it shouldn't be too hard to get consent of all of the adults who are involved with that family. Right? We're not trying to trick people into joining incorporated societies. All right. Okay, so what we're going to do now is I'm going to ask you to type up one important thing that you have learned so far but don't hit enter yet. Okay, so I'll get you to type it all up, and then when I say, we're all going to hit enter at the same time. So think about one important thing that you've learned so far, and then we'll. Okay, I'll answer these questions so they don't get lost in the chat first. Do existing members have to consent retrospectively? No. The expectation is that they're already members, so they're all okay. If you're a regional association with no members but affiliated clubs, what happens? Great question. So most of the time your members are individuals, right? So you've got your organisation and you've got individual people who are your members. If you are a regional organisation with other clubs underneath you, they count for 3 members. So, for example, if you're a basketball Taranaki and your members are all the basketball clubs in Taranaki, then each basketball club is the equivalent of 3 members. So if that's all you have, if you don't have individuals as members, then you need 4 of those clubs in order to make up that requirement of 10. The clubs underneath you are the members, not the people within those clubs. So you can't say, oh, well, we've got like 200 members because this club's got this many and this club's got that many. It's the clubs themselves that are your members. Okay, so they are still members. You do still have membership requirements, and all of the other stuff about consent still applies to them. The difference is that they are what's called a body corporate rather than an actual individual person. All right, so I've got a question about parents of deaf children. Should mum and dad both be registered separately? This is a decision you need to make. It is worth remembering that they are 2 different people and they may not, in fact, be a couple. And so, good practice would be to have all of your members individually consent. Cool. Okay, and I've got a question. Do I need to re-register each year to stay up to date? No. So your current member, yes and no. So for most clubs, your current members will just carry over from year to year. It's not a big deal. And they don't need to re-consent or anything like that. They just pay their subs each year, and that's fine. For some, like for example, we have sporting and particularly sports clubs, we have like playing members or members who are swimming or whatever. They do have to re-register each year. That doesn't necessarily mean that they cease to be a member of your society. So this is one of the situations where you want to think carefully about what situations people cease to be members. So for example, you could say that people cease to be a member at the beginning of the next season if they haven't re-signed for you. Because that registration process is the same every year. They have to re-register in order to play or to participate, but that's not necessarily the same as being a member of your society. It will depend on what your constitution says about them ceasing to be a member. The defaults for ceasing to be members is when someone tells you, which they never do, when they die, or when you remove them for some reason. So you could add in there another thing at the end of the season, but then that might leave you with a few months where you don't have any members, which is not ideal, or at the beginning of the next season if they haven't re-registered for you. Cool. All right. So if you haven't already typed, hit enter and put something in the chat, do so now. Also got some good information here about members consenting. Need to maintain up-to-date records. You have to have at least 10. You have to have a member register list. Finances don't have to be audited. This is correct. Cool. Just a note on the auditing. It's not a legal requirement for the Incorporated Societies Act, but if you receive funding, sometimes those funders might still require auditing as a condition of that specific grant. So it doesn't mean you'll never have to be audited, just that you don't have to have it in your constitution. Cool. All right. So, for members of clubs of a hub, can the member registration protect also be a member of the hub? Yes, this is a really good point. Yeah, so sometimes, so you can be a member of more than one incorporated society, right? You don't have to just pick one incorporated society. So, for example, if you have a like a venue or a sports, or a hub, and there are a number of other societies that use that, you can have those members of those societies also be members of that hub. So I'll use the example from my football club. So I'm a member of Woodley Football. We are not actually an incorporated society. Well, we are Woodley Football is one thing. There's also Woodley Cricket, but we're all part of the Woodley Sports and Social Club. So all our members are both members of Woodley Football, but also members of the Woodley Sports and Social Club. So you absolutely can do it that way if you want all of their members to also be your members. And there can be lots of reasons why you might want to, maybe so that they can access your hub, so that they can do various things, all of that kind of stuff. There's no problem with that as long as it's clear that membership of Kaitaki FC also gives you membership of the Kaitaki Community Sports. Great. I forget what it's called. It's important to note, though, that if you are that higher one, if you're that hub, you then need to keep track of all of those members, right? So you could ask, and again, in that situation, you could ask Kaitaki FC to give you all of their members and to keep you up to date with that register, but you still have that obligation because they are also members of your society. But yeah, that's totally fine. All right, so let's take a little bit of a look at a committee. So the committee is what the Incorporated Societies Act calls your governing body. Now, you might call it something different. You might call it a board or an executive or something like that. It doesn't really matter what you call it. The Act is clear that that's what it is. It's a committee. Right, and there are some requirements around your committee. So the first is that you must have at least 3 members. It used to be 2, it is now 3. Now, I did see an old draft constitution that was floating around. I think it was a sports one that said 2, but it is 3 as the minimum number of committee members. Aside from that, you can set your own minimums and maximums as long as there's more than 3. As well as that, everybody on the committee is what's called an officer. So they're an officer of the society, and being an officer of the society contains obligations. Okay, and these are personal obligations. As well as that, under the new Act, there are now some specific offences if people have done something wrong. Having said that, these officer responsibilities are not new. They've actually been around for a while, but they were in what's called case law. So there were cases that identified that these were the responsibilities of the officers of incorporated societies. Okay, so got a question, President, Treasurer, Secretary, or any other specific names for officers? So everybody on the committee, even if they're just regular committee members, are officers. So obviously it includes things like President, Treasurer, Secretary, but everybody else. Technically, an officer of a society is anyone who, let me just pull up the specific wording, is a natural person, so that just means a real person, occupying a position in the society that allows the person to exercise significant influence over the management or administration of the society. So it's obviously committee members, but there might be times when it's somebody else, a CEO, a health and safety officer, even potentially an office administrator if they are exercising a significant influence over that administration of the society. So just bear in mind that it's not limited to committee members, but for the vast majority of societies, that is who your officers are. All right, so we're going to read some statements, and then you're going to raise your hand if you think it's true, and keep your hand down if you think they are false. So these are your officer responsibilities. Oh, no. When exercising powers, officers must act in good faith and what they believe to be the best interests of the society. So hands up if you think, yep. Go. Yep, this one is true. So you're not acting in your own interests, you are acting in the best interests of the society. Right, you must not act or agree to act to the society acting in a manner that contravenes the Incorporated Societies Act. Is this, or the Constitution? Is this one true or is it false? Yep, this one is also true. You've got to follow the law and you have to follow the Constitution of your society. Must exercise the care and diligence that any person with the same responsibilities will exercise in the same circumstances. Is this one true or is it false? This one is false. You have to exercise reasonable care and diligence. Okay, so it doesn't have to be real high level, but it does have to be reasonable. So even if somebody else in that situation was going to do something, if that's not reasonable, then that's not something that you can do. May exercise a power as an officer for any purpose. Hands up if you think this one is true. Yeah, this one is false. You can only exercise your powers for what are called proper purposes, so the purposes of the society. Must not agree to the society incurring an obligation unless you believe at the time that the society will be able to perform the obligation. And so if you think this one is true. Yeah, okay, so this one is true. You've got to believe reasonably that the society can do the thing that you are agreeing to. If you don't think you can do it, then you should not, bring the society into that. All right, and may allow the activities of the society to be carried on in a manner likely to create a substantial risk of serious loss to creditors. I think this one is true. Yep, I can see some crosses over there. Yeah, this one is false. Okay, so if you think there is going to be a substantial risk of serious loss to your creditors, then you should not do it. And that can mean that if you look at your finances and find that you are no longer financially viable, you actually have an obligation to wind up your society. Okay. All right, so I've got some questions. If we're not currently an incorporated society and someone wants to sue our club based on a decision, where is the liability? So this is a good question. I will say that if you got an email from me telling you about this incorporated society's presentation, you are currently an incorporated society because that's where I got that information from. If you're not an incorporated society, then you are personally responsible for the things that you agree to. So one of the purposes of being an incorporated society is the incorporated society has its own legal entity, right? It's its own thing. It's sitting over here. And it has legal personhood. And so the society is responsible for stuff. The society can sign contracts. The society has liability. You don't personally. So if you were an unincorporated group of people, you're just a whole bunch of people hanging out over here, and one of you signs for some accommodation on behalf of your group, then that person who signed for that accommodation would be personally responsible for paying that. Okay. As well as that, if you own a building, usually you need to be an incorporated society to own that because it's in the name of the society, not in yours. There may be insurance issues as well if you are not incorporated, because an insurance company might only deal with what is essentially a legal thing. Okay, so we've got a question. If our society is not a charity, do we need to know anything about it? Incorporated societies and charities are different things. So an incorporated society is a not-for-profit organisation. It can be for a charitable purpose, and many of them are, but it doesn't have to be. So the charity part is just the purpose for which you are acting. So you can be a charitable company, you can be a charitable trust, you can be a charity in a couple of different forms. You can be a charitable incorporated society. But the form which your organisation takes is as an incorporated society. Right? That's the form it takes. The charity part is just the purpose for which you are acting. And obviously, if you are a charity, you have some slightly different obligations towards charity services. One of the changes here in relation to finances is bringing incorporated societies into line with charities. So that's to kind of level that playing field a little bit, and it's also the case with officer responsibilities, is to kind of bring all of this a little bit more in line. But it's important to remember that the form that your group takes, it's an incorporated society, that doesn't have anything to do with whether it's a charity. Okay, that just has some things about why you are a group. Do we need a consent type form for members of the committee to sign? Yes. So unlike consent to be a member generally, consent to be a member on the committee is a little bit more formal. So it needs to be in writing. They need to be 16 or over. And that's it. Yeah, they need to be in writing and be over 16 in order to be a committee member. You might have in your constitution that people have to, formally apply to be on the committee. That's totally fine. You don't have to do that. They just need to sign a written consent and be the appropriate age, and otherwise not be. There are some situations in which people can't be committee members, for example, if they're an undischarged bankrupt. That's pretty rare. Is there an example of a consent for officers? Yes, there is a consent form on the Incorporated Society's website. You can just download it, print it out, and then get people to sign it. It's very straightforward. I will, just give me a second. I'm just going to have to stop sharing my screen just briefly so that I can pull up the Incorporated Society's website. Right, so there's a whole bunch, I've posted the link in the chat. There's a whole bunch of information on there, including some forms, those officer consent forms that you can complete. Can a society register its intention to re-register, or does this have to include the new constitution? No, you have to include the constitution. There's no point saying, hey, we want to re-register. The Register of Incorporated Societies needs the constitution in order to have you under the new Act, because you need to be operating under that new constitution in order to be operating under the new Act. So, no. Okay. Right, so let's take a little bit of a look now at conflicts of interest. This is a part of your committee obligations. Again, like the register of members and the contact person, this is a kind of recognition that this is something that incorporated societies have historically done very poorly. So there are now requirements around how you manage conflicts of interest as a committee. So there's a little flowchart. So all you have to do, work out which of these 4 things fits into which of the 4 little steps, and then we'll talk about it. So the first step with conflicts of interest is to work out if you are interested in a matter. Now, we're talking here only about financial conflicts. If you don't want someone to do, to get a good deal from your club because they're a dick, that's a thing you can do. All right. This is only about financial kinds of conflicts. Now, you might decide that you actually would like this to be broader than that, and that you'd like it to include personal conflicts of interest. That's completely fine. You just don't have to. In order to work out if you have an interest, basically you just have to, so you have an interest where you personally may obtain a financial benefit, but you also have an interest if you are the spouse, the sibling, the parent, the child, the grandparent, the auntie, the uncle, the cousin of someone who may obtain a financial benefit. So it is very broad. Okay, so it's not just you personally, it is almost anyone you are related to. First cousins, no further out than first cousins. But there's still potentially a lot of people. You're also potentially interested in a matter if your business partner or somebody that you were in business with financially may obtain a financial benefit from it. So in all of those situations, you would have an interest, you'll be an interested member. Okay, you have an interest in whatever matter the committee is discussing. And I was talking to someone, I did a presentation, an in-person presentation, and they said at the beginning of every meeting, they ask if anybody has any conflicts and they make a note of it. So it's actually really good practice. You don't necessarily know that you're going to have an interest straight away. If you work out later on that you might have an interest, then you should raise it then. Then you've got to disclose the interest. You've got to tell the committee that you may be interested in a matter. Now, it doesn't matter. It's not when you're definitely going to receive a financial benefit. It's just where you may obtain a financial benefit. So even if no financial benefit does come to you, you still have to follow this process. So you disclose it to the committee. You then remove yourself from voting. If you are interested in a matter, you cannot vote on it. However, you may be present for the discussion. Now, again, you might think, actually, we would prefer that that person was not present for the discussion. That's totally cool. You can absolutely say that. But as far as the Act is concerned, you can be present for the discussion, but you are not allowed to vote on the matter. And then finally, you've got to keep a register of conflicts of interest. Now that, again, like the register of members, it's a thing, right? It's a register. So it is not just making a note in the minutes. You need a specific document or database or something that shows all of those potential conflicts of interest. So it needs to be separate from your minutes. So you've got to keep that register. So somebody has asked, is that a paid employee? You're not interested in a matter if the reason that you're financially interested is only because it's the incorporated society. So if it's because the incorporated society is paying for something like an employee, then that person is not interested in the matter because it's a different kind of scenario. Again, in that situation, you may still think it's not appropriate for that person to vote in relation to that. That's totally fine. Okay? But they're not interested in the matter solely because the incorporated society is, or if they're reimbursing you for something or something like that. So those are the rules around conflicts of interest. One of the things to remember is that members can ask for the information that your society holds. And one of the things members will often want to know is your conflicts of interest. So it's good practice to make sure you're keeping that register up to date. So somebody's asked, what if a person volunteers but once a year does a subcontract? Yeah, they'd be interested in that situation, right? Because they're a member who is receiving a financial benefit from the society by whatever service they are contracting out. Now, this doesn't mean that your society can't pick them, right? You might still want that person to get, because they've given you a real good deal. Members often do give you a real good deal. There's no problems with that. You just have to disclose it and then put it on the register. So you might say, you might have a member who's a painter and they've provided a quote to repaint the roof of your society building, and it's a real good deal. And so you do actually want to accept that quote, right? They just can't vote on it. You can still choose them because theirs is the best deal. There's no problems with that. It's just about whether or not they can be, how much of the process they can participate in. Right, so let's have a look. So John's on the committee of the rugby club. His partner, Chris, is a painter. They'd like to upgrade their changing rooms, including painting. So just hands up, does John have a conflict of interest? Yeah, so John has a conflict of interest here. It doesn't matter whether Chris is his partner romantically or in business. In both of those situations, there would be a conflict of interest. And again, it doesn't mean that Chris might do a real good deal because, John's his partner, no problems, right? But John can't vote on it. Just the only other thing to bear in mind around the conflict of interest policy is that if more than 50% of your committee has a conflict of interest, then the decision must go to a special general meeting. So for most of the time on your committee, this is likely to be fine, particularly if you've got reasonable numbers. But if you have a very small committee, or many of your committee are, closely related to each other, then you're running some risks here, because the last thing you want is to make it impossible for your committee to actually, do the work that they need to do, because they're always having to go to a special general meeting in order to decide on any matters. Now, it's a little bit unclear if it does have to go to a special general meeting. It's a little unclear about whether or not those members with a conflict can vote. So the theory, very well-meaning of the government, is that you put it out to a special general meeting and your membership at large they'll all appear. They'll come to that special general meeting and they'll make the decision. Realistically, it'll just be your committee that turns up and then they'll make the decision anyway. But provided you've put it out for the special general meeting and they've had the opportunity, then that's just how that one goes. So yeah, so if you've got a small committee or really a lot of people who are related to one another, then you do want to think carefully about whether or not you can manage that conflict of interest properly, or if you need to seek either more committee members or some slightly less interconnected ones. All right, so there's a question, is there a requirement to keep the conflict of interest registered for a period of time, e.g. 7 years? Yeah, I think so. I'm not 100% certain on that one, but 7 years is the kind of standard that you have to keep records for, and you're already having to keep records for your register of members for that time frame. So I would imagine that that is the likeliest time frame, but I'm not 100% certain. Now, somebody said presumably John or Chris only has a conflict if Chris is quoting. This is a little bit tricky. So the question in the Act is if you are interested in a matter, and it talks about voting, but when you look at the definition of a matter, it means a society's performance of its activities or exercise of its powers, or an arrangement, agreement, or contract made or entered into or proposed to be entered into by the society. So the word matter actually is quite broad. So even if Chris hasn't quoted or isn't quoting yet, it still might be a performance of the society's activities, and there may still be a conflict. So it's a little bit unclear about where the boundaries of these, like how early in the process do you have to declare a potential conflict? We just don't have any guidance yet. The Act is still pretty new. So what I would say is that good practice would be as soon as it looks like there might be a conflict, you could disclose it, right? Because again, it doesn't mean you can't be involved in the discussion, and it doesn't mean that, your partner doesn't end up getting it. It just means that you have to tell the committee that there's a potential conflict of interest, and it's a potential conflict. It doesn't have to be a real conflict either. So the earlier, as soon as you become aware that there may be a conflict, that is the right time to declare it to the committee, even if you haven't yet reached the point of quoting. So what would the numbers be if a small committee consists of close family, i.e. 3 out of 7? Yeah. So if you had a committee of 3 and 2 of them were related to each other, then that's more than 50%. So it just needs to be, make sure I've got the right wording, is it more than 50 or 50% or more? 50% or more. So if you've got 7, then you'd need to have 4 committee members to have a conflict, because that's 50% or more. 3 committee members is less than 50%. So that's all it takes, at least half of the committee having a conflict of interest to then trigger that provision, and it must be a special general meeting. All right, any other questions about committees or conflicts of interest?
I have a question. Can I ask it? So we have a multi-ethnic council in Taranaki, and does a lot of things, and part of it is youth council. It's not registered officially because the youth members from 13 till 30, and so we have a lot of things and constant normally present if kids are publicly speaking or kind of photographed or something like that. Do we need to register them as a separate society and give them a thing, or can we run it as it is, like one of our projects?
Yeah, so you can have one incorporated society and then have kind of like sub, groups
Committee.
within that. And that's totally fine. So it just needs to be reflected in your constitution. So if you have a main committee and then you have a subcommittee for example, youth, then that's absolutely fine. If that's what you want to be doing, then make sure that your constitution kind of accurately represents that so that everybody kind of understands. One of the things to bear in mind is that committee members are officers. Committee members are officers, but subcommittee members generally aren't because they don't have that same level of control over the society. So as long as you're clear, then that's totally fine to have subcommittees or subgroups within your incorporated society. Is it a conflict to have domestic partners on the same committee? Not in itself, no. It could cause problems if you have a conflict, right? Because then it's taking out both of them, not just one person. But from a sort of starting point, there's no problem with having people on the committee who are in a relationship with one another. Again, if you want something more stringent or if you have concerns about that, then that is something that you can put into your constitution. But as far as the law is concerned, it's not a conflict. Okay. All right, so let's take a little bit of a look at finances. Don't freak out. Finances are not a really big deal. Just before we go on to finances, I do have some polls that I will launch at the end, asking about the session. These are a requirement that I have in order to do my work. So if you can hold on for those polls before you go, I'll put them up hopefully just before 2:30. So finances, the criteria in the Act is actually pretty straightforward. You've either a small society or you are a not small society. And this is defined, a small society spent less than 50,000 in each of the 2 preceding financial years, total current assets of less than 50,000, and is not a donee organisation. Now that last one is basically being a charity. So if you are a charity, then you cannot be a small society. But that's because if you are a charity, you are already meeting that higher level of financial accountability. So this doesn't impose any higher level on charities than what they are already doing. So it's just the same as what you are currently doing as a charity. So let's take a look at an example. So all you want to do is work out, is the golf club a small society? Okay, so we've got the golf club. They spent 30,000 in 2023, but 55,000 in 2024, and they have lots of money in the bank. So hands up if you think they are a small society. Cool. Yeah, so the answer here is that they are not. They are a not small society. So they have to meet a slightly higher standard. Again, not particularly high though. This is just if they have operating payments of less than 120,000, but more than 50,000, then they just have to provide a cash reporting report to the incorporated societies. That's a not small society. If you are a small society, you basically just have to provide a balance sheet, so a spreadsheet with incoming and outgoing. Those are the minimum requirements under the Act. So as I said at the beginning, you're probably already meeting these or even exceeding them. There's no problem with that. You can absolutely be exceeding things, but that's the minimum requirements. Just a note though, when they talk about current assets means cash and cash-like assets. It does not mean fixed assets like a building. So if you own a building, but you don't have much money in the bank and your operating payments are low, you would still be a small society. Okay, so it's only cash and cash-like assets that count as current assets. The other thing to be aware of, and you might have picked this up, is that it's in each of the 2 preceding financial periods. So if for some reason your operating payments are less than 50,000 last year and they were less than 50,000 the year before, but then when you come to do your ones for next year, you've had a big grant and your operating payments have shot up, at that point you would be a not small society, right? Because your total operating payments are more than 50,000. But once that 2 years is gone, you might fall back down into being a small society. So it's not fixed. Okay, so if you're a not small society now, it doesn't mean you're going to have to be at that level forever. If your operating payments and your assets decrease considerably, then you don't have to provide those same levels of reporting standards. And the reporting standards, it's the XRB reporting standard 4, which is the cash one. And then if you get up a little bit higher than that, then it's an accrual-based one. But by the time you get up to that point, you should be able to kind of have the money to be able to do that system. So somebody's asked, why is it important to be defined as a small society? I mean, it's just, these are defined by the regulations, and what the Ministry of Business, Innovation and Employment looked at was kind of where the majority of incorporated societies sat, because they didn't want to provide requirements that were going to be really onerous to large numbers of incorporated societies. So the vast majority of incorporated societies are either small societies, which only have to provide the bare minimum in terms of finances, or they're not small societies, but with operating payments of less than 120,000 a year. So that's a think about. I want to say like 80% of incorporated societies fall within those categories. So that's why they've put them where they have. Why they've defined a small society versus that lower level of not small society, I can't tell you. It's just one of the decisions that they have made. One of the things that they are trying to do with the finances here is to bring incorporated societies' finances into line with things like charitable trusts and charities and other kinds of organisations. So I suspect that those are kind of the same kinds of levels that you see for other not-for-profit organisations. All right, take a moment, have a big stretch. I will launch these polls. Oh, yes, there we go. Right, so I've launched some polls about how you found the session. If you could complete these before you leave, that would be fantastic. There you go. There are 2 of them, so please click on both of them and then click submit. There will be time, we do have time for a little bit of questions. Just a gentle reminder, we are at the pointy end of this process, particularly because you do have to go through that process of redoing your constitutions, and that will take time. What I will say is that the societies that have re-registered generally have someone in them who has been willing to put their hand up and say, yeah, I will do this, and I will make sure that it happens. So if you're here in this presentation, probably that's you. And now is the time to kind of drive that process for your society. If you know people who Yeah, I'm not. Sometimes you can't access all the polls if you're not part of the organisation. I'm not exactly sure how that works. Sorry. So, thank you for letting me know. Um, ah, fabulous. If you know people who are not here today, or if you've got other members of your committee that you think absolutely should hear this information, please do give them my details. I'm more than happy to run another virtual session, and I can come and talk to people face to face. So look out for at least another virtual one this year. And I'm likely to be running another in-person one with the Wheelhouse. However, if you want me to come and speak with your group specifically, or with a group of your organisations, I'm more than happy to do that as well. I want all incorporated societies in Taranaki to have access to all of this information before April 2026. So please pass on anything to anybody, and I will absolutely organise some more stuff as well. We have got a question about what is the reporting requirement under the new rule? Is it in relation to finances?
Yes.
Yes. So the reporting requirements are, if you're a small society, you're basically just providing them with it's basically just a spreadsheet. This was our income, these were our outgoings, this is how much we have left. If you're a not small society, then you have to provide what's called a cash reporting system. Again, it's pretty straightforward, and if you've got an accounting software that you use, then it will absolutely cover that. And again, if it's
a question on that. So previously we used a template that was provided under I think the Charities Commission to provide the performance report on an annual basis. So when I look at the new requirement, the only thing that makes us not a small society is requirement number 2, which is the current asset is more than 50,000. So if I have a read about the financial reporting or requirement on this, it says that if you do not meet this criteria, then you have to use the new XRB template. Is that correct?
Yep, that's correct. So I'll just again, it's on the website that I posted that link. Let me see if I can pull up the specifics. But yeah, it's the XRB standard reporting requirements. The financial side of things isn't my strongest suit, but there is.
Yeah, I think there is a new template that we need to use.
Yes.
After you register, after you re-register. So basically, if let's say that you want to submit the performance report for the current financial year, you can still use it based on the old template. But after you submit, then you re-register the following year, you need to use the XRB template, correct?
Yep, that is correct.
Yeah.
So this is, where am I? Oh, sorry, I've lost myself. There we go. So this is the information about the XRB standard for tier 4, which is for that one's under 120. The next level up is tier 3, which again is for higher than operating payments of more than 120,000, but less than, I think it might be it's quite high, 2 million possibly. So that's the tier 3 one, and there is also a template on that Incorporated Society's website for small societies to use. So I just want to reassure you, it's probably not worse. It's probably not harder than what you're currently doing. You might just need to use a slightly different template. Cool. All right, so thank you. If you've got any more questions, please feel free to ask. I will just put... So as I said, Taranaki community law where I work, we provide free legal services for people who can't afford to see a lawyer. We can help people where you want a little bit of extra support for your constitution. That would be easiest probably to get hold of our main office. So that's 0800 529 878. There is also an organisation called Te Ara Ture, which, let me see if I can find their website. They can provide free support for people maybe who might like their constitution reviewed or looked at by a lawyer. There's no guarantees with them that someone will be able to do it, but it is a possibility for you as well. And otherwise, if you've got members who are lawyers, hit them up. Now is the time to kind of make themselves useful to your organisation. If you've completed the poll, you don't have any further questions, thank you very much. You can also find Taranaki Community Law on all the social media, and I will post a bunch of information about incorporated societies there. So thanks.
Thank you.
Thank you.